Good morning, all. Welcome to the final day of the April oral argument session of the Pennsylvania Supreme Court. I recognize we're not in the courtroom, but we do have a live YouTube audience. The protocol is I'll introduce the cases with a very brief introductory statement. Call upon the lawyers who've been provided protocol sheets or are aware of the way we do oral argument. Appreciate all who are interested enough in the civics and the court system to watch. Brian, do you want to call the first case?
First argument is Charlene M. Rellick-Smith versus Betty J. Rellick and Kimberly B. Vasil. Representing Ms. Rellick-Smith is Mr. J. Carmella. Representing appellees is Mr. Jesse David Daniel.
This case concerns the coordinate jurisdiction rule. A first trial was overseen by a judge who determined that appellees had failed to plead the defense of the statute of limitations in an answer containing new matter. Accordingly, the judge barred appellees from arguing the statute of limitations during a trial proceeding. Following an appeal regarding a separate trial court determination, the case was reversed and remanded by the Superior Court to the trial court. The initial trial judge had retired, and the case was then overseen by a second trial judge. The appellees filed a motion to amend their answer to add the affirmative defense of statute of limitations at that juncture. The second trial judge exercised his discretion and granted that motion. This court granted allowance of appeal to examine whether the coordinate jurisdiction rule precluded the second trial judge from granting appellees allowance to amend their pleadings to add the affirmative defense of the statute of limitations after the first trial judge had deemed this defense waived for failure to plead it. Mr. Carmella, you want to introduce yourself and proceed?
Thank you, Your Honor. My name is Jay Carmella. May it please the court, I appreciate all of you letting my client and I present our case to the court today. On the surface, the issue before the court is fairly simple. It is not overly complex. We are asking this honorable court to find that the Superior Court erred in affirming the trial court's decision to permit the defendants to amend their answer to include the affirmative defense that the action was barred by the statute of limitations. As Mr. Chief Justice said, this is based on the law of the case doctrine in Pennsylvania, and specifically the coordinate jurisdiction rule that is contained inside those family of law. The majority of the Superior Court, in their decision to affirm the trial court, used approximately one paragraph to find that the law of the case doctrine did not apply because of the fact that the trial court judge, the Honorable Judge Hanna, and then the later trial court judge, the Honorable Judge Bianco, were addressing different procedural questions. We disagree with this opinion. The initial answer in this matter was filed, in October of 2014. No affirmative defenses were addressed in that initial answer in 2014. 4 months later, in February of 2015, the appellees filed a motion to dismiss the action on two separate grounds, one of which is not relevant today. The separate ground was that the action should have been barred by the statute of limitations. The judge, as stated, ruled that their effort to bar the action because the statute of limitations was not filed properly or in their answer as required under Pennsylvania Rules of Civil Procedure 1030, that their ability to assert that the affirmative defense was waived. An appeal occurred on a separate matter. No cross appeal was filed by the appellees on the issue that their affirmative defense was waived. As a result, ultimately a year later, the case was remanded to the trial court. Discovery was held. Another year went by. The appellees filed a motion for summary judgment, making no reference to the fact that the action should be barred by the statute of limitations. A third judge, the Honorable President Judge William Martin, dismissed that motion. And then ultimately, approximately about a year later, 3 months before trial, the appellees sought to amend their answer to include the affirmative defense of statute of limitations among other affirmative defenses. The appellees now refer to the motion to dismiss in their brief to this court. They're now referring to the motion to dismiss that was filed in February of 2015 as what essentially amounted to a motion for judgment on the pleadings, and that their failure to include any affirmative defenses in their original filing in October of 2014 was merely an inadvertent oversight of prior counsel for the appellees. However, we believe that the record shows that is not the case, that the appellees under prior counsel made a strategic decision in 2015 to not seek to amend their answer to include affirmative defenses. They were obviously aware of the potential issue that the statute of limitations had run, or that the action would have been barred by the statute. And instead of filing a under 1033 to amend their answer to include those affirmative defenses, they instead sought to file a dispository motion to have the case dismissed under the affirmative defense that the action was barred.
Mr. Carmella?
Yes.
Chief Justice there, and we're well beyond your 2 minutes. I hope you've had the chance to introduce your case appropriately. I think your argument that you're making to us is that the trial judge who permitted the amendment to the answer in new matter to add the statute of limitations abused his discretion, and not that he was bound by the coordinate jurisdiction rule. I say that because it seems to me that the initial decision was at trial or close to trial, and the decision was that the trial judge would not permit the amendment of the pleading at that juncture. The second time was during pretrial proceedings, as you've described, 3 months prior to trial, and the trial judge had a motion or had a consideration that was different in kind. It was not, should I allow them to argue something that they waived pre-trial now that we're at trial. Rather, it was 3 months before trial, should I allow an amendment to the pleadings, which are freely permitted under the rules. So again, isn't your real argument not that they're bound by coordinate jurisdiction law of the case, but rather that the second trial judge abused his discretion after all the water under the bridge when he permitted this amendment?
Well, Your Honor, I would give a little bit of pushback on the framing that the original motion that was filed in 2015 was actually a file that was seeking to amend their answer. They filed what they just called a motion to dismiss, and they said that the action was barred by the statute of limitations in 2015.
And if I may interrupt, I mean, the case is a little bit of a mess. There is no such thing as a motion to dismiss under Pennsylvania pleading. It's a federal pleading, and they didn't know that. But again, that's in this tortured procedural history, that's just sort of water under that same bridge.
Mm-hmm. Well, I guess why I think that is significant, that that's the way they framed it, is that they were asking not at that moment to amend their answer, but rather for the case to be dismissed. And so why I think that it's ultimately the same issue that was being decided 3 years later is that they were, again, while they're asking the question in front of the court at the time of the amendment was, can we amend our answer? Their goal by amending the answer is to allow the court to then dismiss the case under the fact that the statute of limitations would bar the action. And so that's ultimately why I feel like this case is unique, is that when you look through the coordinate jurisdiction case law in Pennsylvania, I did not find a case that specifically dealt with the issue where a dispository motion was filed on the ability to amend for an affirmative defense, and then later they sought to seek that amendment. So that's why I believe that even though they're titled differently, ultimately the effect was the same. They were asking for the case to be dismissed because of statute of limitation 2015. The judge said no, and then in 2018 they're asking for it amended so it could be dismissed for that same reason.
Counselor Justice Donahue, respectfully, I think this is how you got yourself into the place that you're in right now. The question is whether or not the trial court violated the coordinate jurisdiction rule.
Mhm.
That's the issue before us, is it not?
Yes.
And there are three ways that a subsequent judge can get around a prior ruling of a prior judge in the same jurisdiction.
That's correct. That's correct, Your
The
Honor.
majority of the Superior Court said, well, the procedural posture is different.
Mhm.
And that's why the trial court judge could get around it. But that's not one of the rules. That's not one of the exceptions. The question is, I think, in this circumstance, whether or not the facts changed between the time of the original pleading and that which came later, which this trial court judge granted. It didn't have anything to do with the procedure. And I think the answer is no.
That's correct, Your Honor.
Isn't that your argument? I mean,
That is absolutely our argument. Our argument is that none of the exceptions to the coordinate jurisdiction rule apply as they are traditionally outlined. Absolutely. We do not think that any of those three exceptions apply, and therefore the only basis under which the Superior Court offered in the majority's opinion is in order to assess the coordinate jurisdiction rule, that none of those apply in this case. The facts did not change, the law did not change, and the ruling by Judge Hanna was clearly not erroneous.
Well, it was not clearly erroneous.
Yes, correct.
That's what the test is. Maybe
Yes.
it was erroneous, but it's not clearly erroneous.
Yes, absolutely. Our position is that it was not clearly erroneous.
Because that had to be judged by an abuse of discretion standard, correct?
Yes, Your
The
Honor.
original ruling.
Yes, Your Honor.
And the basis of that ruling is really irrelevant to where we are right now, as I understand this case.
I agree, Your Honor, and that is our position as well. I mean, the appellees in their argument certainly kind of they seemed like they were trying to address the ruling itself back in 2015, but that ruling went unchallenged, and as a result of that, I would believe that it should be considered to be the law of the case, as is necessary for the purposes of why we're here today.
You would agree with Judge Bose in her dissent, correct?
Yes, absolutely. Judge Bose, I agree completely with her assessment of the case. And ultimately, I tried to incorporate much of her dissent into my brief before this court because I thought it was exactly what I was trying to, excuse me, what we were trying to get across in front of the Superior Court.
Why reinvent the wheel?
Exactly.
Thank you.
Counsel, Chief Justice Berrigan, can you distinguish Riccio versus American Republic Insurance Company from your case?
Yes, Your Honor. I believe that what makes this case different from not just that case, but then the plethora of case law out there on the law of the case doctrine is that we had a motion to dismiss filed on this issue. And so in theory, the seeking to amend the pleading would be going back in time prior to when a motion to dismiss should be considered by the court. And so why I believe this case is different is that the issue that they sought in 2015, the case be dismissed because it's barred, is the same as the issue that they sought to have it dismissed under 2018. And while there are obviously 3.5 years went by, there are other procedural steps that occurred. What I believe they're trying to do is to go back in time to that original stamp, to the original place prior to their motion to dismiss and start that action over again. And I don't believe that the other cases that are out there on this issue had that exact thing where somebody was trying to go back to before the judge issued before they filed their motion to dismiss on the exact issue that they are then trying to amend to include.
Thank you.
Justice Todd, counsel. It seems to me that, I mean, unless I'm missing something, this case, as set forth in Judge Bo's dissent, this case actually represents exactly the scenario that the coordinate jurisdiction rule, the law of the case rule, was meant to address. I I am missing any argument to the contrary, so I'll certainly ask your opposing counsel that. But this seems to me to be vintage law of the case.
Your Honor, I'm in full agreement with that position, and I believe I actually used those exact words in my appellant's brief to this court, was that this is exactly that scenario. Yes.
Well, I didn't mean to quote you without citing the brief.
Yeah, thank you. Sorry.
Any other questions from anyone? Counsel, you've articulated your case well. If you want to sum up, I'm not sure you have to, but if you want to, in a sentence or two, feel free.
I appreciate that opportunity, Your Honor, but I think the court is well aware of what we're arguing here today, and so I thank you for your time.
Very good. Mr. Daniel.
Thank you, Your Honors. To please the court, my name is Jesse Daniel, and I'm here today representing the appellees in this matter, Betty Rellick and Kimberly Vassell. In sum, Your Honor, our position today is that the coordinate jurisdiction rule does not apply in this case. The reason for the fact it does not apply is because the order that Judge Hanna issued does not conflict with the order that Judge Bianco issued. In short, Judge Hanna's order is simply a recognition of the pleading rules that say if you don't plead something, then it is deemed waived. But the law states that that waiver is not inalterable, and it is possible under the right circumstances for a later trial court to allow a party to amend to add that previously unpled affirmative defense. We also don't think the coordinate jurisdiction rule applies because of the procedural posture exception, specifically that at different times when there are different facts and different legal standards, although the outcome of what a decision might be it might be changed by a court, if there are different facts and law considered by the subsequent judge, that it is appropriate to make a different finding, and the coordinate jurisdiction rule does not apply.
How did the facts change? How did the facts change?
Happy to answer it, Your Honor. The facts changed because back in 2015, when the initial motion to dismiss what I think is actually a motion for judgment on the pleadings was set forth, the facts were, what are the facts set forth in the pleadings, all inferences going to the non-moving party. However, later, when Judge Bianco considered the motion to amend a pleading, the standard in that matter is whether or not Mrs. Charlene, the appellant, would suffer any prejudice by the amendment. And there are completely different facts considered.
Sorry to interrupt you, but you're explaining different standards that apply. I was asking, how did the facts change? Did the facts change?
Expand, Your Honor. Yeah, in the pleadings issue, the motion for judgment on the pleadings, there was no factual consideration as to whether or not any witnesses had lost their memory or there was any prejudice sustained thereby. Said another way, the testimony of Miss Marcoldi, who is the supposed prejudice the appellant has alleged, what she remembered, what she knew, what she didn't know, was not involved in the motion for judgment on the pleadings in any which way, shape, or form. There was no factual consideration of whether or not she had lost any of her memory, or again, there was any prejudice suffered. None of those facts were involved in any which way, shape, or form in the initial decision on the motion for judgment on the pleadings.
Well, that's because it was a motion for judgment on the pleadings.
That's correct, Your Honor. These motions and what we're dealing with are completely separate procedurally. You're dealing with a motion for judgment on the pleadings, which has different factual and legal considerations, compared to a motion to amend a pleading, which has different legal and factual considerations. So although I agree that the effect arguably is the same, allowing us to plead a waiver, the considerations are different. And if you look at the case law on this matter, it's the considerations that are taken into account to decide this, not the effect.
Okay,
Well,
can
it
I
seems
follow
to
up,
me that
counsel?
this is really an example of seeking a second bite at the apple on an issue that's already been decided. Maybe you can persuade me otherwise.
I feel I have a high hill to climb, Your Honor. I will take a shot at it. Bottom line, I don't think this is a second bite at the apple because at no point in time did prior counsel request to add the statute of limitations as an affirmative defense. So we can't really have a second bite at the apple when the first time we asked to amend, which is in 2018, that we never asked for that in the first time. Candidly, I think prior counsel, although to horse the record, simply made a mistake. He forgot to plead statute of limitations. He unfortunately didn't look at his affirmative defenses, and he just filed his motion to dismiss, motion for judgment on the pleadings. And Judge Hanna properly pointed out you can't get relief on an affirmative defense you failed to plead. And with that, she spent one paragraph.
You just conceded,
Sorry, Your Honor.
counsel. You just conceded properly with your duty of candor to the court that your prior counsel blew it. I mean, this is just obvious. The most basic rule of Pennsylvania practice, or one of them, is you have to plead your affirmative defenses in your answer and in your new matter. He blew it, and it's not a clearly erroneous ruling. It's law of the case, and I have no idea where your prejudice rationale or analysis comes in, and the Superior Court analysis comes in. Isn't this black letter law? The judge made a ruling. It was not appealed. There was no motion to amend the new matter to add statute of limitations back when such a motion could have been brought. It's okay. Let me ask it this way: were we to rule in your favor and affirm this Superior Court decision, what is left of the coordinate jurisdiction rule in Pennsylvania?
I believe there is plenty left, Your Honor, because I don't believe the coordinate jurisdiction rule is applicable in this situation, specifically as to the different facts and procedural postures and in the considerations that went into these decisions. To address the cross appeal issue, which I've heard brought up a couple times, the Superior Court, we briefed this issue to the Superior Court. We were the ultimate victors in front of the trial court when it was dismissed. We have no legal duty to file a protective cross appeal, and the actual case law says you shouldn't file a protective cross appeal. So the fact that we didn't appeal this issue at the time of the 2015 ruling has really no effect on this whatsoever. I would also suggest to the court that the coordinate jurisdiction rule will continue to bar individuals trying to get a second bite at the apple. If we had requested of Judge Hanna back in 2015 to amend our pleading, specifically saying that's what we'd like to do, which was never done, and then 3 years later when there's a different judge, we make the same request based on the same facts, and then Judge Bianco decided to say, yeah, we'll go ahead and allow you to do it, that would be an issue. Now, again, I think in this pleading situation, it's not applicable because, again, I don't think there's any conflict. To agree with the appellant's position would effectively be to say, if you fail to plead an affirmative defense, and then later on that automatically results in waiver under applicable law, but later on you then try to come back and say, hey, Judge, we failed to plead this, now we'd like to plead it. I think the law of the case would say, well, you can't do that now because you've already waived it by failing to plead it previously. Maybe to sum it up, Your Honor, there is a host of case law about how the policies behind these rules is not to allow failures of lawyers, just mistakes, technical deficiencies in pleadings, to deprive individuals of meritorious defenses or decide the cases, that we've moved away from that type of gamesmanship. And what really we're looking to do here is to allow substantive defenses to come forward so these cases can be adjudicated on the merits. I think everyone in this case has agreed, even Judge Bosenhurst's defense, that the statute of limitations was a very meritorious defense here. And it would be unfortunate if my clients were unable to present that defense due to a failure by counsel previously, where the other side, when we asked to fix that failure, was unable to show any prejudice so as to prevent that from happening, thereby allowing the liberal rules that govern pleadings to let us put forth this affirmative defense.
Mr. Daniel, it's Justice Todd. I really don't want to argue with you on this. I just have one follow-up question. Is there any justification that you can come up with for failing to request amendment at the time the ruling by Judge Hanna was made rather than 3 years later?
Based on the record in front of you, Judge, no, because that would require me to get into what happened, why did prior counsel do what he did, and that dehors the record. I can speculate as I did in my brief, but I don't think that's a good use of our time unless you want to hear it.
I appreciate your candor. Thank you.
Sure. In sum, I do think that the coordinate jurisdiction rule will survive if you would uphold the decision of the trial court and the decision of the Superior Court. I believe it will continue to be an important rule that shapes the judicial system. But in this situation, it just doesn't apply. There's no inconsistencies between the orders. The factual and procedural positions at the time were very different between the two orders. And to the extent that one of the three traditional exemptions to the coordinate jurisdiction rule applies, I do believe if you look at Judge Hanna's ruling, if you read it to mean that you've waived this defense and you may never, ever, ever bring it up again, I do believe that is a clearly erroneous ruling based upon the case law and voluntary relinquishment of a legal right. This was just a, hey, you didn't plead it, so I can't give you relief on it. That shouldn't result in a party never then being able to add it. So that aspect of Judge Hanna's ruling would be clearly erroneous. And as to a manifest injustice, it would be a manifest injustice to prevent my clients from going to trial without a meritorious defense that, again, even the dissent in this matter in the Superior Court said, yes, there was good reason to throw this case out on statute.
Can I ask you a question, counsel? So you're offering, because we need to make a rule that doesn't just apply to your client, but applies across the Commonwealth. So I guess you want us to pronounce in a new precedent here that there's a whole new element to the coordinate jurisdiction rule, that the coordinate jurisdiction rule does not apply if it would create a, quote, manifest injustice, unquote. If that's the case, then aren't we burdening all the courts of Pennsylvania to start doing an independent manifest injustice analysis in every case where the rules would work some kind of hardship on a litigant? And if that's the case, how are we not going to get hundreds of different outcomes and rules from all the judges across this Commonwealth?
I am absolutely not asking you to do that, Your Honor. There is already established an exception to the coordinate jurisdiction rule set forth in the Zane case, which states that if the prior holding was clearly erroneous and a manifest injustice would occur from the enforcement of it, then the trial court is empowered to ignore the coordinate jurisdiction rule and make a different ruling. So I'm not asking you to create any new law here. I'm simply asking you to apply existing law set forth under Zane. And I think Zane is not an outlier. It's very well established. Again, one of those exceptions is to the coordinate jurisdiction. The prior decision is clearly erroneous, and there would be a manifest injustice by its enforcement.
You just conceded it was not clearly erroneous. I thought you've essentially stipulated that your prior counsel blew it, failed to plead limitations in new matter. So ipso a fortiori, Judge Hanna's ruling on that is not clearly erroneous because it's not even erroneous. You're talking in circles. I'm not getting what you're saying here.
I can, if the court will allow me, I'll take one last chance. I don't believe Judge Hanna's order is a statement that my clients inalterably waived the statute of limitations by which they would never, ever, ever be able to bring it up again. I believe Judge Hanna's decision is purely a statement that it is, you didn't plead, I can't give you relief. To the extent that this court does, though, read Judge Hanna's order in that broad sense, you didn't bring it up, so you can never bring it up, then I do believe it is clearly erroneous under the law set forth under our brief, and I think law that we all know, liberal allowance of pleadings and allowing these matters to be decided on the merits.
Any other questions at all? Counsel, thank you very much. Well presented.
Thank you, Your Honors.
We'll take a 5-minute break to allow counsel to exit, new counsel to come in, and we'll hear the next case.
sorry. The next argument is trust under will of Augustus T. Ashton, appeal of Elizabeth A. Reed. Representing Ms. Reed is Mr. Stanley R. Ott. Representing Appellee PNC Bank is Ms. Hera K. Jacobs. Representing the Attorney General is Ms. Claudia Tesoro.
And Mr. Ott, our protocol is that I do a brief introduction for virtue of it, typically in the courtroom, but today our courtroom being YouTube, and to make sure for all counsel that we're on the same page. In this matter, the Orphans Court held that a named annuity beneficiary of a trust who receives a fixed $2,400 payment per year has standing to sue to challenge both the administration of the latest account of the trust, the trustees commission, and the fee agreement, and to seek appointment of a successor trustee of the trust. The Superior Court reversed, holding that the named annuity beneficiary did not have standing to pursue these claims. The court reasoned that the named beneficiary's entitlement to $2,400 annuity did not give her a direct, immediate, and a substantial interest in the aforementioned claims sufficient to confer standing upon her. Even if her claims were successful, it would not affect her ability to receive her annuity payment under the Superior Court's rationale. The issue is whether the beneficiary has automatic standing to raise these claims or otherwise have standings to raise these claims. Mr. Ott, if that is substantially correct, free to proceed.
Thank you. Chief Justice Baer, Justices of the Supreme Court, may it please the court. I am Stanley Ott, counsel for appellant Elizabeth Ashton Reed, great niece of the settlor whose trust is before you today. This court must decide to do either of two things. One, insulate a trustee like PNC and its professional brethren from the long-established fiduciary duty of trustee loyalty, and thereby freeze out a named, vested beneficiary without a record based upon an apparent determination that the beneficiary's interest is insufficient in relation to the entire trust corpus, or remain consistent with more than 100 years of trust law that recognizes the unique status of a vested income beneficiary of a trust to challenge a trustee's conduct and fidelity. Opposing counsel repeatedly note that Ms. Reed is entitled only to a yearly distribution of $2,400 and refer to her as a mere annuitant. In trust law, however, our client is a vested income beneficiary, a status she has enjoyed for 70 years. No Pennsylvania court had issued a published opinion holding that a vested income beneficiary of a trust lacks standing to file objections to a trust accounting or to challenge her trustee's fidelity until the Superior Court did so here. Its 2-to-1 decision reversing Judge Carafiello deviated in its analysis of Pennsylvania trust law, and if allowed to stand, would substantially change it by ignoring the right of all vested beneficiaries to assert that a trustee breached its absolute duty of loyalty. Judge Carafiello got it exactly right when he overruled PNC's preliminary objections by noting that the standing of a vested income beneficiary is both, quote, ordinary and automatic, close quote. His opinion notes that PNC cites no authority to support its assertion that a named vested beneficiary of a trust lacks standing to raise objections to a trust account. Then and now, they cite none, because there is none. Though not expressly stating, Superior Court established a proportionality test, which a vested beneficiary must now first pass before her standing can be recognized by an orphans court adjudicating a trust accounting. The subjective test will create great uncertainty, prompt the routine filing of preliminary objections, and work a mischief that will bedevil both orphans courts and litigants. That decision and its resulting test were in error and should be reversed.
Mr. Ott, Chief Justice Baer, well said, and I understand your point. It seems to me the issue in the case is should her status as a income beneficiary provide automatic standing. I
Correct.
think that's your argument. However, if there's no automatic standing, we fall back to the well-established law of standing, which you need to have a substantial direct and immediate interest. You need to be aggrieved. So I don't think that a decision adverse to you, respectfully, is going to shake the foundation of Pennsylvania law. It's merely going to determine that a trust beneficiary is not exempt from the obligation to be aggrieved. Can you shed some light on why I'm wrong?
I'd like to, Mr. Chief Justice. Standing determinations at their core resolve who is sufficiently aggrieved in order to participate in litigation. In garden variety civil cases, that determination can be difficult, and the William Penn parking garage case is a great illustration of that difficulty. Hence, in those cases, an articulable standard arose, the so-called three-pronged test. In trust law, however, determining who is aggrieved is not nearly so difficult, and the use of the three-pronged test can resemble an effort to put round pegs in square holes. Vested beneficiaries who enjoy equitable interests in the whole of the trust corpus and to whom high duties of loyalty are owed by fiduciaries are clearly aggrieved by the misconduct of trustees, hence their automatic standing. Now, that's not to suggest that the three-pronged test is never used in trust cases. Milton Hershey School and the Barnes Foundation are two that come immediately to mind. But it's important to remember that in those cases, the test was used because those who were attempting to intervene were not beneficiaries, but rather private citizens or entities. The trust beneficiary has that unique equitable interest in the trust corpus as a whole, an interest in the race of the trust, if you will, that satisfies or force that three-pronged test.
Mr. Ott, could you explain to me, I understand completely your argument that proportionality should not matter, does not matter, but in follow-up to Chief Justice Baer's question about is she aggrieved, does it matter that regardless of the outcome of this litigation, she continues to receive exactly what she's receiving now? Does that matter?
Respectfully, it does not. And here's the reason. At the present time, our client has alleged 4 specific objections that deal directly or go directly to allegations that PNC has breached its fiduciary duty of loyalty to the trust. 2 others are related to those breach of loyalty allegations. Case law is clear. Noonan estate from this court, and then followed up by Harrison estate in the Superior Court, that if in fact the fiduciary breaches its duty of loyalty, the issue of harm isn't even part of the case. It must disgorge its profits, even if the trust wasn't harmed a bit. That's because the law that's built up around the duty of loyalty cases is deemed to be inflexible and prophylactic in nature, so that it creates a chill or a removal of the temptation, if you will, to do that which you're not supposed to do. The fiduciary duty that a trustee holds to its beneficiaries is among the highest that the law allows or requires.
I understand that, Mr. Ott, I'm sorry. I understand that, but we're talking about standing here, right? And
We are.
whether she is aggrieved.
We are.
Okay.
And I thought I was addressing your question about, does she still have the interest required as a vested income beneficiary, notwithstanding the fact that she receives that yearly payment of $2,400? She does have it because as a vested income beneficiary, she has an equitable interest in the whole of the trust, indivisible, if you will. And the overlay on top of that is the fiduciary duty of loyalty to the trust, which she has a right to attempt to enforce.
Thank you.
Councilor Justice Donahue, could you sort of align your argument with the provisions of the trust code that allows relief to affected beneficiaries. Under
Sure.
your scenario, the adjective or the descriptor affected is totally unnecessary because you're saying any beneficiary, but the trust code provides relief to affected beneficiaries.
Your Honor is referring to section 7782, 7783 of the UTA. And any analysis of that question begins with section 7706. 7706 talks about preserving the common law of trusts and principles of equity, except as modified by that statute. What that means, first of all, is that lengthy body of law built up over hundreds of years, referencing the equitable interests of all vested beneficiaries in the corpus of the trust, the race, if you will, continues to exist unless the statute modifies it. The next section that needs to be looked at is 72, which is the codification of the trustee or fiduciary's duty of loyalty. That part brought right into the statute. Now, let's get to the question of affected. That's used in both 7782 and 7783. Interestingly, affected beneficiary is not one of the defined terms in section 7703, which is a definitional section. And there is not a single case reported in any event that has attempted to interpret that section. That requires us, in defining what affected means in that context, to the normal use of the term. Affected means impact. And then you look at the context of that section in overall context of Orphans Court law. That brings in, I suggest to you, Orphans Court Rule 2.5. Rule 2.5 is the one that talks about the types of notice that must be given by a trustee filing a trust accounting to interested people. And it says to whom that trustee must send it and what must accompany it. If you are a qualified beneficiary, that term is defined in the UTA section 7703. My client is a qualified beneficiary. There is no dispute about that. She is a present income distributee and she is vested. A qualified beneficiary under Rule 2.5 is not only entitled to receive notice of the filing of it, he says it wants a judicial discharge for. And she has the right, by virtue of that, to file a timely objection to any of that. My answer to your question is affected not being defined. I believe, and I suggest to Your Honor, that being vested means affected because a vested income beneficiary in the history of trust law has always been deemed to have a sufficient interest, and to the extent that the allegations here are a breach of loyalty, I can't underscore enough the significance of that. That is a separate issue which any vested beneficiary can raise, whether she will benefit from it or not, because it doesn't even require harm for the trustee to be surcharged. All that has to be shown is that they breached the duty of loyalty, and any profit they realized must be disgorged, even if the trust itself was not hurt by it. That was the very situation in the Harrison estate that the Superior Court followed Noonan in, saying that an attorney who represented the estate as an executor got a referral fee from a lawyer to whom he sent a matter. That referral fee did not come out of the estate. It did not affect any of the beneficiaries of it, but he was still required to disgorge it because the duty of loyalty was violated. And any vested beneficiary can bring that allegation. They have to prove it, of course, but they have the right to do it, and she has the standing to do it. So to answer your question, bottom line, vested means affected.
Counsel, is this a surcharge action?
I'm sorry, could you repeat that?
Is this a surcharge action?
It's hard to tell at this point, Your Honor, and here's the reason.
What is it? You brought it. I mean, is this a request for a surcharge?
At this stage, and let me explain that stage, all we got to was the account was filed. Our client filed objections raising allegations of the breach of loyalty. And at that point, PNC filed the preliminary objections, overruled, of course. And then an interlocutory appeal was granted, and that decision was reversed. We haven't gotten past the pleading stage yet. We haven't begun discovery yet. Where the case goes, I respectfully suggest, is really difficult to speculate about at this point. Yes, it might well be a surcharge action, but I think that has to follow the facts and the development of them that would occur in discovery. We're simply looking for a seat at the table to prepare the case and make our case.
Well, you have to know some facts. You've alleged breaches of fiduciary duty.
We know the facts that are available and clear from the accounting that's been filed. This is a 34-year accounting, extremely large, and it does reflect investments that have raised concerns about a number of specific objections, and specifically those objections, the four direct ones I'll tell you, and these are based on what the information is in the account. First one, investment mutual funds or money market share classes when less expensive share cases were available. Second, investment in proprietary PNC funds or affiliated funds as self-dealing. Third, investment in securities using soft dollars. And four, investment in securities where an affiliate of PNC received more favorable trading results. We've been able to glean that, infer that from the information given. The facts in detail about that must be obtained in discovery.
Counsel, how would a search, let's say this develops to the point where it's a request for a surcharge. How does that differ from a breach of fiduciary duty claim?
Well, it is a breach of fiduciary claim. And
how is it different? Is there a difference if you put a title on it of surcharge, request for a surcharge?
Well, I think what you may be asking me, and please correct me if I'm wrong, is there a difference if your theory is a breach of loyalty as opposed to a breach of mere mismanagement, which, by the way, the Superior Court mischaracterized our objections to be. They said it was merely objections relating to mismanagement. They weren't. The objections go directly to the breach of the duty of loyalty. Is there a difference there? There is, in the sense that a breach of loyalty requires no showing of harm to the trust at all, and the trustee can still be surcharged for the unfair profit that it keeps. The trustee can only receive reasonable compensation as agreed to by the parties or as approved by the court if it's receiving any benefit, monetary, outside of that. That's self-dealing, and that is disgorged or the subject of a surcharge. That's different from mismanagement. Mismanagement has a different set of standards to it in determining how much the surcharge would be. I hope that answers your question. If I didn't interpret it,
yes,
I'm happy to address it further.
Mr. Ott, Chief Justice Barrett, following up, Justice Donoghue, were you done?
Yes.
I was following up on Justice Donoghue. I just know parenthetically that PNC over 70 years took this from a $1.6 million trust to a $73 million trust. Frankly, in my many years at the bar, that's an unusual result for a corporate trustee. However, putting that aside, my question to you is, if we permit you to go forward on the merits of the case, and you prove breach of fiduciary duty, breach of loyalty, surcharge, does your client get any of the money that would flow from, I presume, from PNC to the trust?
Well, to the extent that she has an equitable interest in the trust as a whole, she's benefited by having the trust enhanced, if you will. Whether she gets any of that money is speculative at this point, because I don't know how long she will live and how long it's going to be paid out and what the future of that trust will be. But she benefits from an enhancement of the trust.
Yeah, but that, I don't want. I'm not going to argue with you. but she gets $2,400 a year from a $73 million trust. Assume that she lives to 100, assume that the PNC caves and says, yes, there was a breach of fiduciary duty, settles the case and pays another $10 million to the trust, and now it's $83 million. Does she get any of that? I understand your answer is she's benefited if the trust goes from 73 million to 730 million. Does she get any of the money? Does she? What I'm exploring, I appreciate your argument is she has automatic standing, but I'm exploring if we reject automatic standing, is she aggrieved?
Well, she's
She
aggrieved.
has a greater interest in this than I do, because I'm sure I'm not going to get any of the money from this trust.
She may not receive any more than the $2,400 that she's receiving now, and she may well receive that until she passes away. But that, I would respectfully suggest to you, is not does not resolve the question of whether she's aggrieved. She's aggrieved because of the violation of the fiduciary duty that the trustee owes to her, as well as to every other beneficiary of this trust. And the case law of this court for 100 years has recognized the right of a beneficiary who has suffered at the hands of a trustee who breached that duty, the right to call that trustee on the carpet for it case, regardless of the harm to the individual beneficiary. The case law is clear on that.
Which again is the root argument, which is automatic standing.
This is an automatic standing case from our perspective. Yes.
Okay, thank you. Any other questions for any justice at all? Mr. Ott, well presented. If you want to sum up in a sentence, feel free.
Well, I would simply say that
You don't feel compelled. You don't win on the volume of words.
I understand that. You've given me an opportunity to state the case, and I appreciate that. But in summary, my client is entitled to a seat at the table, and that's all she asks. She wants to be able to pursue it. She has to prove it. If she can't prove it, it falls. But she has the right to try, and she has the right to proceed further. And we would ask that you would reverse the Superior Court in that regard. Thank you.
Thank you for your argument. Mr. Jacobs, Tesoro, I understand you're both going to argue, Ms. Jacobs, I apologize. I understand you're both going to argue, we have a rule that you don't get rebuttal by virtue of a number of arguments. So if you separate your arguments, as I think you've already told, we appreciate that. I will stop you if you begin to argue the same thing. Whoever's going to argue first should feel free.
Good morning. May it please the court. Harry Jacobs from Ballard's Bar for the appellee PNC Bank. And as mentioned, I am splitting argument this morning with Claudia Tesoro from the Office of the Attorney General. My argument is going to address the black letter law on standing, why the appellant here doesn't meet that test, that there is no exception to standing for a trust beneficiary, and why appellant's arguments to the contrary are wrong. Ms. Tesoro is going to address the role of the Attorney General's Office for Charitable Trusts, why the appellant's position here is contrary to the public interest, and the harm that will come from Ms. Reed usurping the Attorney General's role. I am also going to address and start with the scope of the arguments by appellant on appeal. Appellant contends that the Superior Court erred when it ruled she did not have standing on 3 items. Number 1, to object to the 4th account. Number 2, to object to the proposed fee arrangement between Penn and PNC. And number 3, to seek the appointment of her daughter as a co-trustee. As a threshold matter, appellant here is foreclosed from arguing about the Superior Court's holding concerning her lack of standing to object to the fee arrangement and to seek appointment of her daughter as co-trustee, because these issues are not set forth or suggested by the statement of question involved as required by Rule of Appellate Procedure 2116. And this court stated in Worth v. Commonwealth 626 PA 124 that this rule is mandatory. There are no exceptions. The issue stated by appellant for appeal, and which this court granted review on, and I'll paraphrase here, is did the Superior Court err by finding that a current trust beneficiary does not have automatic standing to object to alleged breaches of fiduciary duty by a trustee? That issue does not encompass appellant's objections to the proposed fee arrangement between Penn and PNC, or appellant's request to have her daughter appointed as a co-trustee. And for that reason, these issues should not be addressed by this court. Turning now to the issue that is raised on appeal, appellant's contention that a current trust beneficiary has standing to object to conduct that does not impact her at all has no basis in the law. None.
Counsel, may I ask you on that one? You say has no impact at all on her. Offer us, if you will, please, a workable test that can be stated as a matter of Pennsylvania law as to how courts are to determine when the equitable interest is sufficiently large to allow a beneficiary to attempt to police the conduct of a trustee. In other words, I think by saying she's not affected, you're going to this proportionality test. I'd like you to hear your opinion on where that comes from, by the way. But what is the litmus test or black letter rule you propose by which we would say a beneficiary has enough interest to allow to police the conduct and the dealings of the trustee?
Justice Weck, the legal standard for that is the universal test for standing that's been set out by this court and has been consistently followed. And that is, does the beneficiary have a substantial, direct, and immediate interest in the outcome of the litigation? And that means when you look at that and you apply that here, does Ms. Reed have, and we'll start with the objections to the fourth account, does she have a substantial interest in those objections? She doesn't. And the reason why she doesn't is because an account is a transaction, is a record of the transactions of the trust over a period of years, here 30, 40 years. During those 34 years, her interest is an annuity, a $2,400 annuity. There's no dispute. It was paid every year. She has no interest in the alleged conduct of the trustee that she has set forth, because her interest in the trust has not been harmed. And with respect to arguments that have been made about the duty of loyalty, she has no interest in the outcome of the litigation there as well, because it doesn't matter. It wouldn't matter hypothetically if PNC was required to put money back in the trust. Her interest in this trust is the same. It is $2,400 and putting money back in the trust. She doesn't get any of that money. And importantly, the beneficiary here who would get it, Penn, is totally opposed to her objections.
Counsel, this is Justice Doherty. How then does her vested interest get protected if she wants to challenge the improper dealings of the trustee or the self-dealing, which could affect her $2,400?
She doesn't have standing, and she shouldn't have standing for a very good reason. One of the key purposes of standing is to ensure that the proper party is before the court. Someone in Ms. Reed's position who hasn't been harmed, okay, there's no dispute about that. And even if she wins the matter, okay, isn't getting $1, should not be the party before the court litigating the matter. And especially in the trust context, where under the law, the trustee, if it is successful in the litigation, if the trustee is successful, the trustee is entitled to have its legal fees paid out of the trust. So in that situation that you're posing, Ms. Reed is going to litigate a very expensive case. Okay, she's not the proper party. because, to put it bluntly, she has no skin in the game.
Excuse me, this is Justice Mundy. If she doesn't have any standing, why would you send her the formal audit notice in January of 2018, telling her she can object to the filing?
Well, Justice, standing is not the requirement for sending that audit notice. Okay, I believe that Judge Ott referred to that you need to be a qualified beneficiary. A qualified beneficiary is not someone who has standing. And so that is why she would get the notice, because that is statutorily required. But there is nothing in the statute that says that a trust beneficiary who gets the notice, that after they get the notice, can come to court and throw up objections in which they are not aggrieved, they are not harmed, and absolutely no stake in the outcome of the litigation.
Ms. Jacobs, Justice Todd here. According to your opposing counsel, however, she does have an interest, or she can be aggrieved because the result could enhance or diminish the trust. And she has, as a qualified beneficiary, an interest generally in the value of the trust. Could you respond to that?
Absolutely. To be clear, a beneficiary does not own the assets of the trust. And as Justice Donahue explained in her decision in McAleer, what a trust beneficiary has is an equitable right to derive benefits from the trust assets. And so in the question that you're raising, for example, the appellant here has an equitable right to derive benefit from the trust assets. But her equitable right to derive the benefit, what is the benefit she's entitled to derive? Well, that depends on what the trust says. And here the trust says it's $2,400 a year. So in the question that you pose, putting more money back in the trust does not change what she has, which is the right to derive a benefit from the trust assets. And that benefit is limited to $2,400 a year.
Could I follow up on that briefly, counsel? I mean, it seems to me you're arguing a case as if it's an arm's length contract transaction case and not a trust case involving fiduciary duties to the person, to one of the people who has the equitable ownership. In this case, a life interest, an annuitant. Let me test your skin in the game argument. So you say she's got no skin in the game. Suppose there were not one Elizabeth Reed. There were 36 Elizabeth Reeds. The settlor had a large family. And they all got this beef with how PNC is selling or whatever PNC is doing to pay expensive lawyer fees out of the trust corpus or what have you. 36 of these Elizabeth Reeds. Enough skin in the game then? My point is, are we going to direct our trial judges across this Commonwealth and the Orphans Court divisions to weigh out a numerator and a denominator and say, well, there's just one Elizabeth Reed, there's not enough skin in the game, so no standing. But here we've got Elizabeth Reed and her 20 cousins. Okay, that's enough skin in the game. I'll let you have standing. Well, how is that a test?
So, Justice Weck, first of all, the test is not a numerator and a denominator. The test is when a party comes to court during the entire accounting period, there's no question, okay, they haven't been harmed. And then if you're getting to this second question of can the beneficiary demonstrate that the conduct she's alleging the trustee engaged in, that conduct, is that going to harm the beneficiary going forward? You do what you do in any case, which is apply the substantial, direct, and immediate test. It's not a numerator and a denominator test. And courts apply it all the time in a very wide variety of scenarios. But it is, and it is important, that it is the burden of the litigant coming forward to establish that that person does have standing, so that you have a proper party before you and you have a legitimate controversy. And I want to add to that, the flip side of the current situation is this, and that it is the notion that there should be automatic standing for a trust beneficiary would be terrible policy. First of all, it would ignore the intent of the trust settler. The trust settler set out, for example, for an annuitant, that their interest is limited to getting paid that annuity and nothing else, and giving a beneficiary standing to go and argue about trustee conduct that does not impact the only interest that the annuitant has violates the settler's intent. And second, this case is a perfect demonstration of where this goes wrong, in that if any beneficiary can challenge the conduct of a trustee by throwing up an allegation of breach of the duty of loyalty, then any beneficiary can challenge trustee decisions for an ulterior motive merely by making that allegation and use expensive discovery as leverage for settlement. And it's the trust who's spending the money on the discovery, and the other beneficiaries who are against it are the losers.
Chief Justice Bear, you're making a lot of assumptions here. The settler thought enough of the beneficiary to name her, in this case, a beneficiary, recognizing that gives her arguably an interest into perpetuity in the trust, as she gets her $2,400 a year into perpetuity in the trust. So, it seems pretty speculative to me to say that the settler would not want her to be a watchdog for this trust, would view her differently, to use the hypo I used I thought that would view her differently than the settler would view me, because the settler didn't think enough of me to give me anything from act as watchdog.
Chief Justice Bear, if Augustus Ashton wanted Ms. Reed to act as a watchdog, he could have provided for that in the instrument. For example, he didn't provide for her to have any role at all, for example, in the scholarships with respect to Penn, anything else. The only thing he provided for was $2,400 a year. And respectfully, if that's the only interest the trust settler provided for, then that's the settler's intent. And going beyond that, basically, interferes with the settler's intent.
Oh, and I'm waiting to hear. I think I'm waiting to hear from AG. I think one of the things you're not saying that we'll get to in due course is both the University of Pennsylvania and the Attorney General and its role vis-a-vis trust have a watchdog role. So if this trustee, this $2,400 a year beneficiary, Ms. Reed, does not have a watchdog role, that doesn't allow PNC to be abusive to this trust.
That's certainly correct, and I am trying to be extraordinarily careful so that there is no overlap between myself and Ms. Tesoro.
Fair enough.
Counsel, can I go back to the topic that you're addressing for us? I really have two questions. One, just confirm for me, when in the ordinary course, when a court makes a determination as to whether or not an interest is substantial, direct, and immediate, there's always a balancing that takes place. Is that not correct? I mean,
that is correct.
Okay, a court could decide that there's an interest, but it's not an interest that's substantial, or it's not immediate or direct. Am I understanding this area of the law correctly?
Absolutely.
Okay, my second question goes to an issue that I tried to probe a little bit with opposing counsel. When a surcharge action is brought, there is no requirement that harm to the trust be established. Am I correct?
So let me back up for a second, Justice Donahue. First of all, I was hoping to address, first of all, I think you had asked, and I promise I will get to your question. I believe you had asked Judge Ott whether there was a surcharge requested in this action, and there is. It's set forth in the relief for the objection. So with respect to, so a surcharge is a type of relief, and the claim for which it is true, no loss is required to establish a claim for breach of the duty of loyalty. However, that does not mean, simply because no loss is required for that claim, it doesn't mean you don't need standing to bring it. That is not stated, and in fact, it's Section 7783 that expressly states that recovery for basically a breach of duty of loyalty, it limits recovery to an affected beneficiary. And who is an affected beneficiary? I mean, the word affected is the same word.
What does that term mean? What does the term affected beneficiary mean as it's used in the Uniform Trust Code?
Justice Donahue, it's true that the term affected is not itself defined, but I would certainly say that the term affected is the same term that is used by this court and many other courts to define standing. It is someone who is adversely affected, and that's what the term affected beneficiary means.
Okay, so just so I understand the answer to my question, although no harm need be established in the context of a surcharge action, the harm that's being discussed is no harm to the trust raise, but you still need standing to bring the surcharge action or request surcharge relief. Do I have that right?
So my difficulty with that is that surcharge is a much broader term. There can be many instances in which a court could say a surcharge means that the trustee takes money out of their own pocket to put it in the trust.
Correct.
And that could happen in a variety of instances. The only claim where no loss is required is a breach of the duty of loyalty. There are other claims for which a surcharge could be awarded where a loss is absolutely required.
Okay. Thank you.
So I wanted to conclude, and I was discussing before why it is that giving a beneficiary automatic standing would be terrible policy. And that is because it would truly enable trust troll litigation. And what I'm presenting here is not a speculative hypothetical. The appellant in this case served 118 discovery requests. She has a pending petition to increase her annuity 2,700% based on the 2,700% that this trust has increased over its life. And the very expensive litigation she is pursuing is not going to be funded by her. It's going to be funded by the income beneficiary, Penn, and it's opposed by Penn and the Attorney General. And granting a trust beneficiary automatic standing may open the floodgates to trust troll litigation. There is no good basis to have automatic standing for a trust beneficiary, and respectfully, the opinion of the Superior Court should be affirmed.
Can I ask you a question on that, counsel, before you turn it over? Suppose Penn, instead of this annuitant, this pesky beneficiary had challenged this, would Penn be a trust troll?
Absolutely not. Penn is an income beneficiary, and to give a hypothetical, if there was an allegation of breach of the duty of loyalty, and money went back in the trust, it is Penn, right? Their scholarship program would benefit because there would be more money in the trust being paid out as income to Penn. They're in a completely different position.
Thank you very much. We'll hear from your co-counsel, Mr. Soro. Ms. Tesoro, you're muted.
I just realized that. Can you hear me now?
Yes.
May it please the court, I'm Claudia Tesoro. I'm from the Attorney General's office, as you know, and the Attorney General is involved in this case because of the Attorney General's unique role as parens patriae in overseeing charitable trusts for the benefit of the general public. From the Attorney General's perspective, the Attorney General, you could say, has automatic standing to become involved in cases such as this where a charitable interest is at stake. But the appellant's unprecedented argument for automatic standing for herself is a departure from existing law for the reasons that Ms. Jacobs has already summarized in excellent detail. It not only is at odds with general standing principles that we are all familiar with, but it also departs from the concept, the very concept that the Attorney General has a parens patriae role and is responsible for overseeing the operations of charitable trusts for the very reasons that were set out in, most notably, the Pruner case, but also the Hershey Trust case and plenty of other cases in Pennsylvania jurisprudence. That role, frankly, is completely not a factor for the appellant's analysis here, and that's very troubling. Justice Baer, I think, earlier brought up the question, which is really the key from the Attorney General's point of view here, and that is who has the watchdog role. The beneficiary, in this instance, the University of Pennsylvania and the scholarship program, has a watchdog role in order to protect its specific interest. But the Attorney General's office and the Attorney General on behalf of the entire Commonwealth has the watchdog role that hopefully would safeguard this trust or any other trust from the kinds of problems that might or might not arise. The key is, again, that the trust, the vast majority of this trust is set up for the purpose of the scholarship program. The university that operates that program is entirely satisfied with how things have been operated. And the Attorney General, upon review earlier in this proceeding, was satisfied as well. The specter of terrible things happening is in the air, but as the Superior Court acknowledged it twice in its opinion, it is the job of the Attorney General to step in and take action if necessary to make sure that a trustee, whoever it is, does not go astray.
Could I jump in on that question? Just to ask you a question there, counsel.
Sure.
Nobody questions Attorney General's standing here or the role of the Attorney General. The question I have for you, and you've talked about the specter of having seeing the trust divert corpus money to an unbudgeted expense for litigation here, et cetera, et cetera. Does your position mean that just because you have standing, that beneficiaries also don't have standing? In other words, it seems to me that your argument that you want to prevent unbudgeted expenses depleting the trust going out for this litigation could be made by the beneficiary here who says, I'm concerned, it seems to me that PNC is unnecessarily depleting or mismanaging the money. Why isn't the beneficiary entitled to get some discovery on that?
Well, this comes back to a point that I think Ms. Jacobs made, which is the premise of the appellant's argument is that she's entitled to automatic standing because of this link to the trust and this abstract desire she has to oversee it. But she does not have automatic standing. There is no case law basis or intellectual basis for that legal conclusion. So we we must go back to whether she as a beneficiary has standing in the, I'll call it the common sense of the three-pronged test, aggrievement due to substantial, direct, and immediate interest. If she had that, then she would have standing and she could pursue the case as Ms. Jacobs has acknowledged, and there would be a whole different story. But she doesn't. She doesn't have the kind of interest in this matter that would allow her to do what it is the Attorney General's job to do, basically. It's
Mr.
really
Resso, Justice Saylor here. But the judge, Judge Carafiella, very able Orphans Court judge, said that she did have a direct, substantial, and immediate interest in the outcome, but he anchored that in this premise that a conclusion to the contrary would allow trustees to bypass their duty of loyalty so long as they pay their annuities on time. Now, doesn't that have resonance to you as the Attorney General?
not under the facts we are dealing with here. I think that
Well, go back to what the trial judge said, and that's what we ultimately review. He said this beneficiary has a substantial, direct, and immediate interest in the outcome of this litigation because a contrary result would allow trustees to bypass their duty of loyalty. Let's limit it to that, so long as they pay out these annuities. Now, that's what's wrong with that finding?
I think the problem here is that there's no basis, as I understand it, to find an issue about the duty of loyalty.
Well, that's a different issue. That's a different issue. And as counsel for the appellant said, that's subject to proof. They just want to get in the door. And that's all we're talking about. Whether there's a breach of duty of loyalty is a different issue. But you can't get there unless, as Judge Ott said, you get to the table. It seems to me that I can't understand why the Attorney General wouldn't support that proposition. Or are you so focused on the interests of Penn, the large public beneficiary?
Not only is the Attorney General focused on the interests of Penn, as you put it, but the Attorney General's total concern is the public interest in general. And if this trust is allowed to be questioned and attacked in the manner that Ms. Reed wants to do it, the inevitable result appears to be not just to undermine the trust that Penn has, but also there is a ripple effect for other public interest matters and a diversion of trust assets, as Ms. Jacobs explained, to litigate the case, whatever the outcome. So that just
what would this woman be required to have? An annuity of $26,000, an annuity of $2 million?
I don't think it's a question of a single point on a continuum of dollars.
Well, how would she ever mount a challenge by saying there's a breach of duty of loyalty? How would she ever get in the door?
She would have to show that loyalty to her as a beneficiary was compromised.
Well, she couldn't show that because she's always going to get to $2,600.
That's exactly right.
That's the be all and the end all for you.
In this scenario, it is the end because she does not. That is not jeopardized.
So she would have to sit back, hypothetically, and this is all subject to proof, and watch and accept what she, rightly or wrongly, or appropriate to her counsel, seems to be a breach of the duty of loyalty. And she has nothing to say about that. She would have no way to get into court. She would have no way to challenge that because you pay her the $2,600 every year.
I don't think that there is any case law support or legal support to stand for the proposition that a trust beneficiary who asserts that there has been a breach of loyalty, by simply saying that, is entitled to litigate the kinds of concerns that Ms. Reed is trying to litigate here.
Thank you.
Counsel, it's Justice Donahue. Let me follow up on that. The trial court's view of this, which Justice Saylor just articulated, he would be correct if she were the only beneficiary under this trust. Correct? There's no other beneficiary. I mean, per se, would not her interest then be substantial, direct, and immediate?
If this were a trust with one beneficiary
Correct.
named Elizabeth Ashton Reed,
Correct.
well, she would have a much more substantial, direct, and immediate interest in the running of the trust if she were the only beneficiary. I agree with that.
But isn't that what's wrong with the trial court's analysis? Because the trial court was viewing this in a vacuum. I mean, there were other beneficiaries to this trust, and forget about it being a charitable trust. I don't think that really makes a difference. I'll do deference. But I mean, there were other beneficiaries under this trust who had the incentive to assure that the duty of loyalty was in fact followed by the trustee. So
That's
it's
true.
not as though the trustee would, with impunity, could avoid its duty of loyalty.
I think you're correct, Justice Donahue.
Because the trial court makes a good point. I mean, if the outcome is what he suggested that's problematic. But I think your point and your co-counsel's point is that's not what the case that we have here. There are others who have the interest and incentive, to put it mildly, to make sure that the duty of loyalty is enforced.
That's exactly right.
So is it your view, counsel, that there are following up on that there are first and second class beneficiaries, as it were? There's the great big University of Pennsylvania that gets X dollars, and then there's this pesky, puny little beneficiary who gets this trifling annuity, and they need to be treated, and they need to be analyzed on separate planes in terms of our trust law.
No, I wouldn't say that. Because the settlor, Mr. Ashton, designed the trust that way. It's not that there's something, intrinsically bad about an individual, but the settlor created the trust with the great big university scholarship program on the one side and the specified family members and descendants on the other, of which Ms. Reed is one and nearly the last one. But that's not a question of law. That's what the trust is designed to accomplish by the settlor. Just to wrap up, because there is, under our interpretation of the law and PNCs and the universities and the amicus for that matter, there's no standing under the normal criteria here, and there is no automatic standing. Ms. Reed's approach is unsupported legally and contrary to the public interest. So we ask that the court affirm the judgment below.
Chief Justice Baer, Justice Wick, let me just do this. It'll be really quick. If instead of giving her $2,400 per year, Mr. Ashton had given her 2% of the trust, regardless of what it was, and therefore, to the extent it went higher, went lower, it impacted her yearly benefit, would she have standing?
I think that would be a different case, and it's a little bit like the dividing the trust issue that the Superior Court said she does have standing to consider or to litigate, because her own interests could be affected. But this is not designed that way. This trust was not set up that way.
I understand. Justice Wick?
No, it's Justice Doherty. Counsel, I have a question. You said the trust is not designed that way, and yet you negate the argument that the monetary amount of the receiver does not determine standing. Yet, if I'm not mistaken, UP is a residual beneficiary. Therefore, you are arguably saying, or you're asking us to say, that a individual, Mr. Ashton, who set the initial beneficiary being Ms. Reed, and the residual is to go to the college, they have a larger interest as residual. Is that what you're asking us to do?
I'm not sure.
And I'm asking you this from an attorney general's perspective, that, as you said, you are protecting the citizenry of Pennsylvania.
I may be missing something, Justice Dougherty, but the way the settlor envisioned this, it was always for most of his assets to be used for the scholarship program. And that's been going on all this time. They didn't have to just sit and wait until every other beneficiary was died or disappeared. It's what the university explained in its brief as a split trust.
I believe that's a request that they have. They're a beneficiary, they are a residual beneficiary, if I read the briefs correctly. Maybe you and I read different briefs.
Well, I hope not, but I think that the residual part of it is what is tripping me up here, because the creation of the scholarship program was immediate upon the death of the settlor, and there was all these assets in the trust that were used or available to be used for that. The university isn't going to be the sole beneficiary until all the other beneficiaries are deceased, and then it'll be a pure charitable trust. But for the moment, it's pretty darn close to that, and that seems to have been Mr. Ashton's overarching intent.
Fair enough.
Any further questions from anyone? All right, counsel, thank you very much. We'll take the case under advisement. We'll take a 5-minute break before we do the final case.
So the next argument is Commonwealth of Pennsylvania versus Sharon Jail and Purnell. Representing Mr. Purnell is Miss Maria Heller. Representing the Commonwealth is Mr. Eric T. Washburner.
An autistic minor witnessed appellant shoot and kill the victim in this case. At appellant's trial and over appellant's objection, the trial court allowed the minor witness to testify with the assistance of a comfort dog. The jury ultimately convicted the appellant. On appeal, the Superior Court affirmed the use of the comfort dog. The court concluded that the trial court did not abuse its discretion by allowing the witness to utilize the comfort dog, reasoning the trial courts have broad discretion to control their courtrooms, including the power to control the mode and order of examining witnesses and presenting evidence. This court granted allowance of appeal to address the propriety of the trial court's decision to allow the minor to testify with the comfort dog present. Ms. Heller, please proceed.
Thank you, Your Honor, and good morning to all the members of this honorable court, and thank you for giving me the opportunity to address you on this matter. Our case presents obviously a question of first impression in this Commonwealth, the use of comfort dogs to accompany a testifying witness. Let's start with the two things that we do know. One is that the comfort dog is a special accommodation and it's governed by Pennsylvania Rule of Evidence 611, which the goal of which is to reach truthful testimony. And the second thing is that this is a potentially prejudicial thing that we're using, and that should be examined under the fair trial rights of the PA and U.S. Constitution provisions. The way I look at this is a two-part consideration for trial courts. The first is, why is the special accommodation being requested? And they need to create a record. And how does this special accommodation allow this particular witness to get to truthful testimony? And that is where I believe the trial court erred. In this case, Chief Justice Baer said that the witness was autistic, but at the pretrial hearing, there was actually no record of autism. This was a brief mention by defense counsel saying he thought that she was autistic. There was no testimony from AH's parent, guardian, or anyone who could testify to the therapeutic benefits of AH using the comfort dog while testifying. There was no testimony that this is the problem here and this accommodation will get us to truthful testimony. There was no evidence that AH had interacted with the dog and that the dog had calmed her or alleviated any fear that she might have on the stand. In fact, the trial court said, I'm not in a position to know enough about AH. So there was not enough of a finding on the record with regard to anyone who knew this child and who knew what the problems would be. There was also no record with regard to developmental disability by anyone who knew her at the pretrial hearing. And that's in stark contrast to the cases that were quoted in the briefs, obviously from other jurisdictions, such as Hakimi, Cliff, Dye, and Jones. They're all in the briefs. And our record is in stark contrast to theirs in the sense that in Hakimi, you had an expert who was saying that 2 9-year-olds, it's good for that age to hold a doll. In Cliff, you had a guardian ad litem saying the witness wrings her hands, she chews her nails, a doll would help her. In Dye, there was an implicit finding of necessity saying, but for the dog, I don't think we would have gotten this testimony. And in Jones, the mother of the witness testified to his PTSD and saying that the dog goes everywhere with him. He goes to a hospitalization. He was in the hospital with him. He goes to work as a chef. So essentially saying these people are familiar with this witness. This is the problem. And this is how the special accommodation is going to help this particular witness get us to truthful testimony.
Can I ask you a question, counsel? Could I?
Yes, of course, sir.
With respect to the record that you think ought to be required, ought not the move-in, I guess, you in this case, be required to proffer some kind of, make some sort of offer of proof as to how there would be prejudice. Seems particularly important in this case where the dog was never seen by the jury and where ultimately, if I'm not mistaken, your client, where ultimately AH did not identify your client as the shooter. Would it not be required to at least require the defendant, move-in here, to make some offer of how there's going to be prejudice before the Commonwealth's required to prove necessity?
If I understand you correctly, Justice, would you be suggesting that prejudice needs to be shown at a pretrial hearing?
I don't know. I'm asking you. Tell me what you think our standard ought to be in these cases, since this is a new matter for us.
So I do believe that the Superior Court suggested that the standard be that which was adopted in Devon D. The Supreme Court of Connecticut adopted it. And it's a balancing test. So Devon D. basically said that the test should be an accommodation would help the witness. Now, I would suggest that, and then Devon D. in a footnote says a finding that the accommodation will help the witness is also a finding that the accommodation is necessary. I think that really muddies the water, because I think that something that is helpful and something that is necessary, they're really two very different things. I believe the test should be that the accommodation is reasonably necessary to get your particular witness there to truthful testimony.
Ms. Howard, Chief Justice Barrett, I just want to follow up on what Justice Weck asked you. I think Judge Collins, writing for the Superior Court, opined that every court, because we don't have any case law, I think you and all of us have been looking at the other states that have examined this issue. Every court that has examined this has found that the dog's presence is not inherently prejudicial, and therefore comfort dogs are not banned by courts. And that would seem to say, therefore, that one of the things is Justice Weck said to you that we have to say is it your burden to show prejudice, given that the comfort dog is not inherently prejudicial, or is it the proponent of the comfort dog's burden to show that there would be benefit? And that gets you into an amorphous area of how much benefit, what type of benefit, etc. Child, as you said, child bites her fingernails. In this case, this child, forget autism. I agree with you that it's not well developed in the record, but this child seems to be especially nervous. Indeed, she broke down crying and never finished her testimony. Now, I know that's after the fact, but it seems that the trial judge was correct, therefore.
Well,
whose burden and what's the burden?
Well, let me address the questions in part. So I agree with the court that many courts have found that the use of comfort dogs is not inherently prejudicial, and I'm willing to go along with that. However, it is potentially prejudicial. Obviously, courts are utilizing these in very different ways, whether the dog is in view, whether the dog is referred to as a comfort dog. So, I know that we're going away from our facts at this moment, but if the court, for example, I had a case recently where it was a sexual abuse case and there were many children who were testifying and they all used the comfort dog and it was called a comfort dog. I think this is particularly a problem for the defense. And they were not all alleged victims.
Why is it a problem for the defense? Is it that the dog's presence inherently makes the witness more sympathetic? Is it that the witness is going to be less truthful if the witness is more comforted and relaxed on the witness stand? What's the problem with the dog?
I think that when you use the word comfort dog, it implies that the witness needs to be comfort, indicating that there was some trauma and indicating that this is that it's true what they're saying, obviously. And, for the defense, and to be honest with you, I take the point from the Aplt that anyone can use the dogs. But in this particular case, obviously, it was used with a person who was criminally accused. which I do think is a bit different because you do have the fair trial rights and rights with the criminally accused. But essentially, I will give that it's not inherently prejudicial. But however, I think when you start calling it a comfort dog and you have somebody petting a dog throughout and in view of the jury, I do believe that there is a sympathetic piece there, especially with children. And, you know, it depends on whether the courts decide to use a jury instruction or not, or whether the dog is in view. And how
that argument, how does that compare with a child's use of a doll or a teddy bear? That's obviously for comfort as well. We don't call it a comfort doll, but.
Right. Well, I guess, again, it depends on whether the doll is in view, because many of the courts that examine the doll, for example, the court in Delaware and in Hawaii, they both found compelling necessity and substantial needs with regard to the doll. So clearly those courts found that the doll, a child holding a doll in view of the jury, was prejudicial.
Counsel, this is Justice Doherty. Let me bring this back to Justice Weck's initial question to you. Obviously, we all know Rule 611 of the Rules of Evidence. The concern that I have is as applied every day by trial judges is discretionary at her or his whim. For example, under 611A2, purposes to avoid wasting time. Well, I am aware of certain judges who believe the use of a comfort dog would be wasting the court's time to bring the dog in, get the dog settled. I have that. So in our quest to create an opinion which would be applicable throughout this Commonwealth, is it your position that Rule 11 should in some way incorporate the findings of Devin D., the Connecticut State Supreme Court's balancing test? And if so, would the appropriate mechanism be a motion in limine?
Yes and yes. I do believe that the test in Devin D. Really kind of balances everyone's interests. However, I would fiddle with it a little bit just because of its footnote saying that a finding of accommodation that will help the witness is also a finding of necessity. And I think that really muddies the water.
That's Connecticut Supreme Court's footnote. It would not be this one. The question I have is, as I read the balancing test, it would be incumbent upon the move-in to prove the dog will help the witness to reliability and testify truthfully. It would obviate more drastic measures, AKA, I guess, a separate room or via CCTV. And that is weighed against the potential prejudice to the defendant, including some type of, say, jury instruction or a implementation of some procedure. And that would, I guess, is my position is, or my thought for you is are you articulating that this court find that if a dog is to be required, it would be pursuant to a motion in limine under Rule 611, but incorporating the factors or the balancing test of Devin D.
Yes, Justice Doherty. I do believe that the proponent of the special accommodation should have to file a motion in limine requesting it. I do believe that there should be a pretrial hearing with findings by the court as to how the special accommodation will allow that particular witness to get to the 611 truthful testimony. I do believe that if this court were to adopt a balancing test such as that in Devin D., it shouldn't be that of an accommodation just to help the witness, just because I feel like helping the witness and something that's actually reasonably necessary for the witness to get them to truthful testimony are two different things. For example, in Michigan, they had there was a decision, People versus Shorter, where the person was an adult, non-disabled, and she basically said that it would help her to better control her emotions. That might be helpful, but it's not reasonably necessary. And I do believe that there should be a record developed showing a reasonable necessity for the special accommodation that will get this particular witness to truthful testimony.
Fair enough.
Counsel, how would the adoption of that rule by this court impact the resolution of this matter? Would we be affirming the Superior Court or reversing? Because my understanding is there's essentially no record in this case.
So I feel as though that these are two different matters. If this court wanted to adopt a test for the future, that would be one thing. I don't think it would be retroactively applied. I do feel that the trial court abuses discretion in not making a proper record in terms of whether this accommodation got that particular witness to truthful testimony. And she was definitely an impactful witness in terms of she was a young lady. She was allowed to have the special accommodation. She broke down sobbing, and she was allegedly saw the shooter. And also, I cannot remember what Justice said. She had not identified. She actually did identify the shooter from a photo array. She then recanted on the stand, however.
What's the answer to my question then? Do we reverse the Superior Court?
I do believe
who affirmed the trial court, or assuming we adopt the test that you discussed with Justice Doherty.
Yes, I believe that we would reverse the Superior Court and offer Mr. Purnell a new trial based on the abuse of discretion by the trial court.
Ms. Held, Justice Todd, I would have a hard time finding that the trial judge abused his discretion when we don't have any appellate case law telling him exactly what he should have done, what should have been balanced, and what should be on the record, which obviously we don't have. I don't see any evidence that the trial judge did abuse his discretion.
My response to that is that it was clearly a special accommodation. The trial court knew that and actually said, in all of my years, I've never seen this. To your point that there was not a test out there. However, it was obviously potentially prejudicial since everyone addressed so many different measures to handle it. But also, the court didn't create a record as to why are we doing this? And essentially kind of created this idea that the child was autistic. There was no record on that. There was no record that differentiated her from any other child, or really differentiated her from other witnesses who were also frightened. One of them was brought in shackles. So essentially, the court didn't do its due diligence in terms of saying, why are we doing this?
Well, he may have done that implicitly, but you're right, he did not make a record.
Should we infer from your answer, Justice Todd, that there's a presumption of prejudice? I'm sorry, just a real brief question. Just in your response to Justice Todd leads me to ask you, do you want us to say that courts should infer a presumption of prejudice in circumstances where a dog is going to be provided?
I don't know that. I believe that we need to view this as potentially prejudicial right from the very beginning, because it can be handled in so many ways. If the dog is not trained, or if it's referred to as a comfort dog, or it's being allowed, just generally speaking, I think the question overarching is, should this be allowed to just help any witness who is generally scared, or whether is this a finding for a particular witness? And I do believe that it has to be handled as a potentially prejudicial technique or practice, I should say.
Ms. Heller, I wanted to follow up on Justice Todd, because I think I agree with her. The trial court had Rule 611A, control the mode and order of your courtroom. That's the best that he or she could do. I'm not sure the gender of the trial court judge as I sit here. But as I read the test of Devin D., the trial court seemed implicitly, being a fine trial judge, to meet that test. Let's just say it's he, that the trial court had indeed weighed the prejudice versus the benefit. The dog came and left when the jury was not in the room. The dog was never seen by the jury. There's nothing in this record that the dog was petted during the hearing, or that the dog had his head in the witness's lap, or the like. So there was a cautionary instruction provided to the jury, and an overwrought child. And I don't know that a child has to have an infirmity to be nervous about testifying that she saw a murder and confronting that. So I think Devin D was met in this case, even though it was not articulated. Do you disagree with that?
I agree with the fact that the trial court handled the prejudice aspect of it very well. However, I disagree with the fact that the trial court did not know what the benefit possibly could be to this particular witness. There was no record with regard to anyone saying, well, this child will need X in order to get you to truthful testimony. But I do believe that the judge handled, which is Judge David Bortner, and he basically handled the prejudice piece of it correctly. I believe if you're going to allow it, I think he allowed it in the best way he could. However, I feel like that gatekeeper function of why are we allowing a special accommodation for this particular witness, and how does this special accommodation get this particular witness to truthful testimony? I don't think that occurred.
I think we're about done, but you would like us to write an opinion that says, if I understand you, before a comfort dog is permissible, the proponent of the comfort dog has to articulate some specific malady inflicting the witness which justifies a comfort dog.
I might not refer to it as a malady, but I would say that essentially if the special accommodation is going to be allowed, that the special, why is it that it's being allowed? What does this special accommodation do to get this particular witness? What is the issue? It doesn't necessarily have to be a developmental issue. I don't believe that. I do believe that people can be naturally anxious. However, I think that we all get nervous. I think we all get anxious. I don't think that allows every witness that comes into court to say, well, it would help me to have this dog near me. So I do think that it should be a motion in limine for a particular witness, and to have to show how that accommodation will help that particular witness. Are there any other questions that I might help the court with?
Justice Mundy, I just have one question. Should this rule apply to dolls and stuffed animals also?
I do believe so, because essentially the case law is kind of, it's somewhat the same comfort items. So yes, I do believe so. And I do believe that the test should be a reasonable necessity, not just general helpfulness for the witness. I do believe that there should be something distinguishing one witness from another. It shouldn't be just routinely for everyone who's frightened or anxious who enters the courtroom for a dog to be available.
Thank you very much.
That does it for me. Thank you very much.
Well argued. Mr. Walshberger?
May it please the court, Eric Walshberger from the Chester County District Attorney's Office. This is a case about the trial court's decision to let a scared, autistic 15-year-old testify with an unseen service dog. Prior to the court allowing that, prior to trial, the Commonwealth filed a pretrial motion. There was a hearing, and during that hearing, the court learned several important factors here. Learned that the witness, AH, was going to be 15 years old at the time of trial, was 13 at the time of the murder, that AH was autistic, had learning disabilities, that not only had she witnessed defendant killing the victim, but that later on, the AH's scooter was taken from her and used to physically beat another witness in this case. So she has multiple instances of violence that she observed connected to this case. She had told the Commonwealth that she was afraid to go outside of her house because she knows what happens to people that are considered snitches and that testify in situations like this. And that she was fearful of coming into court, seeing anyone involved with the incident, including the defendant. After all of that, the court took it under advisement, did research, looked to see if there was any guidance from this court or the Superior Court, found none, and it wasn't a split-second decision. There were several follow-up conversations that the judge had with both parties, even up to the day that AH testified. But the court ultimately found that this would help the witness, and I believe, as Chief Justice Baer said, the witness ended up breaking down on the stand and couldn't finish her testimony.
Can I ask you about that, counsel?
Yes.
Because in your that last point struck me in your brief. The crying on the stand obviously is retrospective, and nobody could have known that ex ante. In crafting a standard, which presumably we have to do in this case, of general application, would you agree that necessity for the accommodation needs to be shown in advance and not simply derived on review post-trial?
I don't believe that there is, as the Superior Court said, we agree that there doesn't need to be a showing of special need that some of the other courts in other states have adopted a while ago. More recent courts have found that there isn't a need or a requirement for a special need. If this court does require a test beyond the Rule 611, the Commonwealth would be asking this court to adopt the test from Devin D. And just do that balancing test, which incorporates, is this going to help the witness? Balance that versus any potential prejudice against the defendant or to the defendant.
And just one brief follow-up. In your view, sir, should that be required to be of an evidentiary nature, or could it be based simply on argument of counsel to the trial judge?
I think potentially it could be either one. I think the evidentiary hearing may provide more information if the court needs it, if the court isn't clear on all of the underlying issues. But if based on argument, the court is able to say, yes, I think this would be sufficient, or this would help the witness, I think that would be enough. I don't think an evidentiary hearing should be required, a full evidentiary hearing.
It's Justice Todd. I'm not sure how we would determine, or how a trial court would determine prejudice in advance. You're saying there needs to be a balancing test between the help the dog gives to the witness and the prejudice to the defendant. What would the trial judge do at that early stage to determine if use of the dog would be prejudicial?
I think it comes down to some extent to what measures are able to be taken. In this case, for example, the trial court said the dog can be under the witness stand, which in Judge Bordner's courtroom is entirely covered. It's not an open witness stand that anyone can see a witness's legs, for example. So the dog was not seen at any time. Judge Bordner also devised a way that the witness and the dog were seated in the jury box in the witness stand prior to the jury coming in, and then the jury left before the witness and the dog left. So at no point was the dog seen. Judge Bordner also felt that the term comfort dog might be prejudicial, and he said, instead, I'm going to refer to it as a more neutral service dog. Service dog is an extremely common term. I think just in people's everyday lives, media, a service dog for helping a blind person, someone with seizures, that doesn't necessarily engender sympathy by itself. So I think there are measures that the court can take. If the court is not able to take some of these measures, I think that may change some of the analysis.
Mr. Walshberger, Chief Justice Baer, did your office object to any of those measures? That the dog would come before the Jury was sat left prior to the, or left after the jury left the room, remained out of sight, was not petted, et cetera, et cetera?
I don't believe we objected to any of those. I believe all of those were reasonable in this case. The point of the dog wasn't to kind of show the dog off to the jury, right? The point of the dog was to provide comfort, be there for the witness who's terrifying or testifying to some extremely traumatic things that she had observed. So, having the dog already under there still accomplishes that same goal without, parading it in front of the jury. So I don't believe that we objected, and I think they were reasonable.
Would it be, appreciate you're the only representative of the Commonwealth we have before us on this case right now.
I understand.
Would it be appropriate for us to build those kind of constraints and safeguards? Because we do very much care about no prejudice to a defendant from an extrinsic source into an opinion so that they occurred in every case, or is that part of a trial judge's discretion?
I think it would be in part the trial judge's discretion. And part of that is courtrooms across the Commonwealth are designed differently. To say that the dog has to remain out of sight at the witness stand. In Chester County, that could probably be accomplished in most, if not every courtroom. I don't know that that's the case in other courtrooms across the Commonwealth. So, to say that the dog absolutely can't be seen may not be feasible. So if that's not feasible, are there other methods that the court can take to kind of limit that? So I think it has to be a kind of case-by-case situation, not a hard and fast rule across the Commonwealth.
Thank you.
Okay, Counsel, it's Justice Donahue. Just so I'm clear as to what your proposed standard is, are you in agreement with the proposition that the test should be whether or not the comfort animal is necessary to promote reliable and competent testimony, or are you saying necessity is not the test, it's something less than that?
I think that, I apologize, I agree with the Superior Court that a trial court can decide this solely under Rule 611, and they can decide, is this going to, in their power to control the mode and order of examining witnesses and the courtroom function, that the court can decide it under that. To Justice Doherty's point earlier, will a comfort dog speed up the trial, slow down the trial? Those are all things I think that could be incorporated. If this court finds that, no, that's not sufficient enough, we do need something else, then the Commonwealth would be asking the court to adopt the balancing test from Devin D., the Supreme Court of Connecticut. And to Chief Justice Bear's point, even though the Superior Court said that trial court didn't follow that in our case, I believe that they essentially did without spelling it out point by point.
On the issue of necessity, should we take any guidance or indication from the General Assembly's determination in the Child Victims and Witness Act that necessity needs to be proven before alternative procedures are utilized, keeping in mind that they're, that deals with confrontation clause issues, but should we take direction or a clue from the legislature that necessity is part of this test?
I don't think the court has to, and for the exact reason that Your Honor just said. Those statutes deal with the issue of confrontation clause, and confrontation clause generally kind of has two components: that you're going to physically confront your witness or the people testifying against you, and have an opportunity to cross-examine them. And in this case, having the dog present doesn't impact either one of those. Actually, if anything, it helps the accused, the defendant, have that opportunity to cross-examine the witness with testimony that's not broken up, testimony that's not stopped because the witness isn't able to continue. So I don't think that taking guidance from that is appropriate because there are two distinctly different scenarios here.
And just one further follow-up to a question that I believe Justice Todd asked earlier. The rule that we're devising, does it apply to comfort dolls or toys that a child witness may use? And does it apply to comfort animals like a guinea pig or a rabbit? That's the favorite comfort animal of, and in this case, this child had never used a comfort dog before. Am I correct? This was the sheriff's comfort dog.
It was a share. It was not a personal comfort dog, correct?
Okay, so this was a one and done kind of, oh, this is going to help this kid. But I mean, suppose not a child, a witness has a guinea pig that they take on planes with them and things of that nature. Does that apply here also?
I would think that the court would do a similar analysis. Is there a way for any potential prejudice? Is there a way to kind of mitigate that? Is this going to help the witness, provide the testimony? And is it going to speed up, slow down the trial and so forth? It's hard to say. I mean, we've all heard the stories of different things that comfort animals and stuff that people have tried to take on airplanes and so there's no limitation to that. So I do think that is something that the court could consider. I think more commonly we'll see it with, comfort dogs as the animal, but I think it may be appropriate in a given case for something else.
Okay, thank you.
Any other questions at all? Thank you, counsel. We'll take the case under advisement. We'll stand in recess for lunch until 1 o'clock.
Thank you.
Thank you.